This is Modern Mindset, the show that picks the brains of the world's leading minds to help you unlock yours. I'm your host, Adam Cox, and joining me today we have Richard Denton from OGR Stock Denton talking about probate. Welcome to the show.
Good morning, Adam. Thank you very much for having me.
More than welcome. So thanks for joining. We've heard that there is an increase in fees as government seeks an extra £25 million a year relating to probate. Where's that coming from and what's the consequence of that rising costs?
So, Adam, I think this is something that's been a long time in the coming. And in many respects, the increase that we're seeing that comes into effect today is probably a lot fairer than what potentially would have happened a couple of years ago. So I think this is the third attempt that has been made. I think it has been long acknowledged that the fee that was charged previously, and there were two separate fees, a fee that was charged if a professional was acting, which was £155 for the probate fee, and the fee if you applied as an individual, which was £215, simply didn't cover the cost of the service that was being provided. Previously, we saw recommendations to have fees that were linked to the value of a probate. So at its worst, where you had a substantially large probate of 6 million or more, they were talking about fees of £20,000, which obviously put a lot of pressure on the industry at the time because everyone was trying to get all their probates through because every probate would have paid significantly more than the fees that are coming in today. That was deemed to be unfair and in excess of what was required to ensure that the service was self-funded. So the provision that's coming in now probably is more akin to what we would have hoped to have seen to justify the service fee. Interestingly, as I say, they've now brought it into line. So for the increase when using a professional, we're seeing a 27% increase on the previous fee. But I think relatively a fee of £273, which is the new fee, is, when you look at the overall position, not such a bad change for people. And my personal view is I don't think it's going to put people off either using professionals, and we can talk about why I think there are lots of good reasons why using a professional would be sensible when dealing with administrations of the estate. But obviously it is a real hit to the person in the street who, at a time when they've already lost someone close to them, in most cases, is going to be suffering.
Absolutely. And just for those people that might not be familiar with the term probate, give us a quick introduction. What is probate, and why is it an important process, after, let's say, someone has, if they're experiencing a bereavement, why is it an important part of the legal process?
Okay, so in many cases, in order to access and unlock assets, it's important to get what is called a grant of representation. So where there's a will, it's called a grant of probate. If there's no will, it's called letters of administration. But effectively, if we use the generic term grant of representation, that gives you a flavour. And what that is, it's a court-sealed document that allows the person who is entitled to deal with the estate to realise and transfer those assets to the people entitled to receive them, or to cash them in and likewise transfer them. Without that document, assets are tied up and can't be accessed. The process, in brief, in order to get that, is that you need to ascertain all the assets and liabilities of an estate the deceased person owned. Those assets need to be valued as at the date that they passed away. In many cases, that information would have to be returned to the revenue, and the revenue's permission sought to be able to apply for that grant of representation. And then the court will issue the grant subject to certain criteria being met. And that, as I say, enables you to deal with the release of assets and the transfer of those assets to the person entitled to receive them. So in many cases, it's a necessity in order to deal with an estate. In certain cases, and banks have become much better at this, there are thresholds below which they won't insist on that document being obtained. But as I say, generally, a lot of the estates, certainly we deal with, are going to require a grant of representation.
So it's that legal process of effectively assigning an asset to a new person or having the right to kind of access that asset. And is that something that people can do themselves, or really is it essential that they find a solicitor that's just knowledgeable in that area?
So I think the idea is that the system itself is geared to allow for self-assessment, as many of the revenue procedures are. However, it very much depends. And the reason I say it depends is because, like anything, if you're a layperson, it's unlikely that you're going to have the requisite knowledge in certain cases to be able to deal with it properly. So, for example, where tax is at stake, when preparing the paperwork and preparing the submissions to the revenue, there are numerous allowances that are available. There are numerous legitimate loops that you can use or hoops that you can jump through that reduce the tax liability. And if you don't go to a professional in order to receive advice, like in any sphere, you are likely to miss out on those. And I've seen it on many occasions where there are a lot of people that dabble, shall we say, in probate, for people that purport to be professionals, and they simply don't know the rules. And we've had many situations where when we've taken over a matter for various reasons, we've been able to mitigate tax and reduce the liabilities on estates and ensure that assets transfer in a much more efficient manner. So, as I say, it's always worth taking advice in any sphere from a professional to ensure that you get the best outcome.
That makes sense. And like anything, it's fine if it all goes to plan, but sometimes there are pitfalls along the way that can cause issues. What are the typical pitfalls in the process of probate that can catch people out if they do try and do it by themselves?
Well, I think, first of all, to notice there are a number of different timelines that you need to comply with. Okay, so the first timeline that you would have to comply with is the date for paying inheritance tax, which falls 6 months after the month in which someone passes. Once you miss that deadline, you're certainly into interest, and there's also potential for the revenue to charge penalties. In my experience, certainly over the more recent years, where we see the revenue desperately trying to raise funds for the exchequer, penalties are becoming a far bigger issue than ever before. The same issue applies with actually submitting the application. We've been approached on many occasions by people, over a year into the process when someone has passed and they still haven't submitted a probate application. You have a 12-month window in which to do that. And again, failure to do that can result in there being interest and penalties. And then, as I say, the actual preparation of the documentation itself requires a certain level of skill and certain level of knowledge, particularly, as I say, where inheritance tax is an issue. And there are lots of pitfalls that you can fall into if you fail to do that correctly that, as I say, will have a result.
Makes sense. And if you need professional help, some people will be thinking, right, legal matters, solicitors, money matters, accountants. This is obviously kind of like, a bit of both here, because you're talking about assets, you're talking about inheritance and therefore taxes and things like that. Are accountants not a more logical, professional to work with in this case, or is it really legal advice that people need when going through this process?
So I think there's an element of both to that. And I think it's fair to say that we work very closely with accountants when we're dealing with administrations of estate. And where we particularly find value from an accountant is in dealing with the income tax affairs of the deceased to the date of death and also for the administration period. But also, particularly, we like to ask accountants to deal with what are called estate accounts, which means that they pull all the information together on the estate to ensure that whoever's entitled to receive assets is aware of the assets that they're going to receive. And we like to delegate that to the accountant so that we have transparency on the work that we've done. I think the value in coming to a solicitor, particularly over an accountant, is twofold, really. I think the first point to note is that it's only relatively recently that probate was an activity that accountants could carry out. Prior to that, it was an exclusive legal field that only lawyers could carry out. So accountants are relatively new to dealing with probate. Also, my experience of accountancy firms is generally they'll have one or two people in the firm that will take the qualification, and now suddenly they're the expert in dealing with probate. As I say, there are lots of pitfalls and there are lots of things that you need to be aware of that you only can have through experience. And we have a lot of these types of accountancy firms coming to us where they have a more complex estate. And then I think the second point to note is that dealing with an administration of estate isn't just about ensuring that the assets pass. There are lots of other aspects to it that it's really important that clients receive advice on. In many cases, we will advise on and often prepare what's called a deed of variation. A deed of variation effectively is a mechanism whereby you can effectively rewrite a will up to 2 years after someone has died, but have it treated as if the deceased had prepared the will in that manner. That can often give you significant tax advantages and also allows for inheritance tax planning, perhaps for a parent who doesn't want to receive assets from their own parent, but rather to skip a generation. That remains a legally protected activity, so an accountant would not be able to prepare that document. Most of the estates we deal with have properties involved, so we liaise very closely with our property team to ensure that either a transfer of property or if there's going to be a sale of the property is done, again, in the most tax efficient manner. So by keeping that in-house, it allows us to give a seamless service to our clients. And of course, in many cases, you're having clients for the very first time inheriting what could be significant sums of money for them, and they've never considered a will. They've never considered their own inheritance tax position. They've never considered lasting powers of attorney, for example, all factors that now may be much more important to them. And of course, as part of what we do, we can advise on that and ensure that they implement all of those activities at the same time. And then I think the last point I want to make on this is that, unfortunately, we're living in an increasingly contentious world, and we are seeing more and more probates becoming contentious for various reasons. People see it as an easy opportunity to try and make some money. Most of these things tend to settle, so it's worth having a go. And of course, there's money in a pot that's going to be there to settle the fees for doing it. So it's becoming more contentious, and a big part of the practice that we run is contentious probate, and it allows me to work very closely with my colleagues in that team to ensure, A, that we try and achieve a good outcome for our clients in terms of settling as soon as possible. And we often go to mediation on this, but we often use tax and our tax knowledge in order to structure that so that it works both from a tax perspective, and that then helps with the outcome in ensuring people end up with what they're seeking to get out of this.
That makes a lot of sense, and it's things that I think a lot of people don't really think about because it's not a topic people like to think about. But yeah, if you don't do certain things in the right way, then you might be financially out of pocket or have more stress and hassle and those kind of things. What are the key circumstances that, if someone's listening right now, are the useful triggers to get in contact with you? Is it that they've lost someone recently, or is it about like planning ahead of time? If there's a family member that's kind of old and they're not sure if they've got a will, like what's the right time to kind of get in contact?
I mean, I think there are two aspects to the question, and it's a very good question. The sooner you approach a solicitor for advice while someone is still alive, the more opportunity that you have to do something. And with that, there are two aspects. Sometimes you've come far too late to be able to, for example, give away assets, which may require a 7-year survivorship period in order to take the value out of your estate. But we will often advise, and we've done this on a number of occasions recently, on planning that can result in a significant capital gains tax advantage. So, for example, unfortunately, someone comes to you and their spouse is extremely ill, and that particular couple happen to have assets that have significant gains on them. So they bought properties many, many years ago, significant gains on those property, and they're wondering, is there anything that could be done? We call it deathbed planning. I think it's sort of quite commonly known by that name, but you would consider in a scenario like that to transfer those assets with significant gain, and you've got to consider the tax implications of such a transfer, whether a mortgages, etc. But you would consider transferring such assets into the name of the person who is unlikely to survive. You then ensure that there is a will, that person leaves it back to their spouse, and their passing wipes out any of the capital gains tax that was on that particular asset, allowing the spouse to receive it with a spouse exemption for inheritance tax back with the increased value for capital gains tax. That then puts them in a position that, should they wish to sell that asset when the person has passed and given it back to them, they've wiped out any gains tax that they would have otherwise had to pay. Now, I think you'll get the sense that it's quite complicated, but that's something that can be done very quickly and very shortly before someone's passing, and is totally legitimate planning and is very effective for tax reasons. So there's planning opportunities. Having a will in place is, as I say, very important. We've often seen situations, and we're dealing with a very substantial estate now, where someone passed without a will. The estate's about a £10 million estate, and under the intestacy rules, very crudely, there's about £5 million passing to children. yet there's a surviving spouse who's only in her late 60s, and if the will would have been in place, there would have been an opportunity to route assets through the wife, take advantage of the spouse exemption, and then should the wife wish to do tax planning, that would have been opportune. Now, the deed of variation that I mentioned earlier gives us that second bite of the cherry, but it's nothing like as good planning as getting your affairs in order prior to someone passing. So that gives you a little bit of a flavour for the sorts of things that people should be thinking about. But as I say, there's no substitute for coming well in time.
So think ahead in those kind of situations, kind of forewarned is forearmed. And where can people go for more information if they are curious to learn more about this or to get in contact with someone at your firm?
Well, I mean, my view is always when deciding on where to take professional advice, try and make sure that you're going to someone who genuinely is a specialist in the area. As I say, lots of people dabble as part of various other areas of law that they deal with. In terms of seeking advice from us, obviously the best thing to do is to look up OGR Denton on the website. We specialise in various areas of law. We regard ourselves as a full-service firm, and I think where we particularly try and stand out is that we regard the advice that we give as very commercial. We look at our clients, we look at trying to ensure that they receive advice that's tailored and suits them in all the areas of work we do. If anyone wants to particularly Google me, Richard Denton at OGR Denton, then of course they can do that. And I'm very happy if people have particular questions that they want to contact me about to answer those offline.
Fantastic. Richard Denton there from OGR Denton. Thank you so much for joining me on the show today.
Adam, thank you very much for your time.
And to you at home, thanks for joining me on Modern Mindset in association with Share Radio. See you again soon for more.